I'm criminal defense attorney Eric Kay. Over the years, many of my clients have asked me, what happens if I am arrested for a state crime in Florida? What happens after I am arrested in Florida? The following comments are meant to be a brief overview on the arrest and charging process in Florida. A person is typically arrested in Florida based on an officer witnessing a criminal act or as the result of a criminal act being reported to law enforcement. The officer processing the arrest will generate a report commonly known as a probable cause affidavit. This document sets forth the charge or charges upon which the arrest is based and also includes a short statement of facts which form the probable cause for each offense charged. After being arrested within just a few hours, defendants must be taken to a first appearance before a judge where a bond amount is determined. This bond amount is based on the seriousness of the charges, the defendant's past history, the defendant's ties to the community, and the relative danger to the community that defendant poses. A bond is set and a defendant may post the bond and be released, or do nothing and remain in custody pending other action in the case. Once a person is arrested, the officer forwards his or her reports to the local prosecutor's office for whatever county the arrest occurred in. The reports are reviewed by attorneys in the case of the case filing unit in the local prosecutor's office. It is important to note that the charges listed by law enforcement are merely charging suggestions. Case filing prosecutors will read the reports and determine what the appropriate charges, if any, should be. If an officer arrests someone for A and B, as an example, a prosecutor is free to file the charges as presented, only file charge A, only file charge B, or file charges C and D that the officer never even considered, or in the alternative, file no charges at all. The officer's suggestions have no legal effect except to be a basis for what bond a person has to post to get out of jail. After the local prosecutor's office determines what charges, if any, to file against the defendant, which typically takes 30 to 40 days, an arraignment is set if the prosecution is proceeding with the criminal charges against the defendant. An arraignment is a defendant's first formal appearance in a criminal matter, and the purpose of an arraignment is to formally advise a defendant of the charges he or she is accused of. At arraignment, in certain cases, the state will present an offer to resolve the case. This could typically include anything from fines to probation, to time in the county jail, to time in the state prison for more serious offenses. The offer is generally based on the nature of the charges, the prior record of the defendant, and the victim's wishes if there is a victim in the case. The defendant is free to accept this offer, if desired, and if so, this is called a negotiated resolution or plea. While the judge must approve of the terms suggested by the state, with a negotiated resolution, the defendant knows what he or she is getting to be done with the case. Most defendants that are charged with more serious offenses simply enter a plea of not guilty at arraignment to preserve their rights. A not guilty plea does not mean that the defendant must go to trial. It simply means that at this time the defendant wants to see the state's evidence, fight the case, or explore other options. Typically, when a lawyer is involved, the defendant's attorney and the prosecutor will engage in a process called discovery. In the discovery process, the state must provide the accused with any and all evidence that they seek to use against the defendant at trial. This includes providing any reports, notices of any and all physical evidence, and a list of any witnesses who may be called to testify for the prosecutor. The defendant, through his or her attorney, in response to the state's discovery submission, may elect to take sworn statements of the witnesses, examine the physical evidence, hire experts, and file motions challenging the evidence to be presented. Evidence may be excluded as a result of these efforts, and the case could potentially even be dismissed if crucial evidence is excluded. If the defendant elects to go to trial, the not guilty plea will be maintained throughout the pendency of the case, and a judge or jury, depending on the type of case and the desire of the defendant, will decide whether the state has proved their case. If the defendant, after engaging in the discovery process, decides that a trial is not in his or her best interests, a change of plea to guilty or no contest may be entered to resolve the case. A plea of guilty basically means that a defendant admits to the charges presented and wants to resolve the case. A plea of no contest is often referred to as a plea in that person's best interests without an admission. A no contest plea basically means, I didn't do it, I didn't not do it, but I find it in my best interest to resolve this matter without a trial. If a defendant wants to accept the state's offer with a plea of guilty or no contest, this is referred to as a negotiated change of plea. The defendant knows what he or she is getting subject to court approval. However, if a defendant does not want to accept the state's offer and does not desire a trial either, another option is also available, which is referred to as an open plea. An open plea says to the court, Judge, I do not want a trial in this matter, but I do not believe that I should get what the state is asking for either, and so I would like the court to determine my sentence. Obviously, an open plea is often used as a last resort to resolve a case when a trial is not wise and the state refuses to make any reasonable offers. In most cases, when a defendant enters an open plea, the court will advise the defendant that the judge may sentence them to the maximum amount allowed by law on the offense, and he or she is agreeing to that. This approach requires that the defendant take the risk of getting something worse than the state is offering in order to hopefully receive something more reasonable from the judge presiding over the case. In many cases, this works to the defendant's advantage, but in some cases, the sentence becomes worse than what the prosecutor was asking for. Only an experienced attorney can effectively help a defendant determine if he or she should take their chances based on what judge is presiding over the matter and the unique facts of the case pending. Certain motions which seek to avoid a mandatory prison sentence under the Florida sentencing guidelines, such as a motion for downward departure or a motion for alternative sentence, require that a defendant enter an open plea to the court to be considered for this relief. An accused should speak to a lawyer to further determine if these options may be helpful in his or her particular situation.